Recording in progress.
Good afternoon, everyone on the platform, honorable members of both houses. Razia, if I may check if we do have members from both houses, because I've seen you here. I've seen the Honorable Nyambi, Honorable Janchi. Then, can you please assist me, Razia?
Good afternoon, ma'am. We do have members from both houses on the platform.
We do have.
We do, ma'am. There's no quorum
Okay.
requirement because it is a subcommittee. Thank you.
Yeah. Yes. Thank you very much, Razia. Good afternoon, everyone. Thanks for attending this meeting at this time on a Friday afternoon. Unfortunately, Parliament is at work. We do have other commitments as members of Parliament. Thanks for leaving everything and attending to this meeting. We are all here and the agenda is flighted just in front of us. Honorable members, just to mention that we are co-chairing this meeting, the subcommittee on joint rules. So it's myself and Honorable Nyambi for now because the Honorable Lucas is on sick leave. So here we are, honorable members. We do have we have apologies, Razia?
No, ma'am, we have not received any apologies.
Okay, thank you very much. Honorable members, the agenda is presented before us. Is there a mover for the adoption of the agenda? Because I don't think we should add anything. Honorable members?
Afternoon, Chair, Co-Chair. Before I move, I want to register the one of the Deputy Chairperson of the National Council of Provinces who's still in hospital. After that, I'll move that we adopt the agenda as is. Thanks, Co-Chair.
Thank you very much, Honorable Nyambi, Co-Chair of the session. Is there a seconder for the adoption of the agenda? Honorable Guarinov.
I second the adoption for the agenda. Thank you.
Thank you very much, Honorable Guarinov. Can we now move on to item number 3? I've seen Mr. Kaso on the platform and the other secretary to the council.
Yes, ma'am. Thank
Can
you so
you
much.
please take us through?
Thank you, Honorable Deputy Speaker, and good afternoon, honorable members. We are going to deal with item 3, and I'll also introduce item 4 at the same time, and Advocate Nonyane will present item number 4. Honorable members, we are just highlighting this because it was presented at the Joint Rules Committee in April. A lot in it has already taken place. If you could go to the main, what we wanted to just highlight here, some of the ideas that were there at the time was that at some point there would be a workshop on the current rules and for the committee to familiarize itself with the work that has already been done and the things that that are still going to be done. Please go down. And there was also an idea that perhaps there could be a call for public submissions on the joint rules. Now, I'm highlighting those two issues because I would want to suggest, ma'am, that at the end of the meeting, we could consider whether there's still a need for a workshop, given that we're now having meetings and we'll still have meetings on these rules, and whether there is any need for any public submissions on this matter. So I would now like to move to introduce item number 4, having highlighted the key things that I wanted to deal with here. If I may have the slide presentation, please. And then the next item that I'm dealing with is just to give a summary of what we will be doing. Go to the first slide, please. So, slide 2, yes. The purpose of the review, honorable members, is to incorporate and consolidate recently adopted joint rules. There are a number of joint rules that were reviewed since 2015 to date, and we want to incorporate those. And we want to align the joint rules with recent jurisprudence affecting Parliament, whether it is to do with the legislative process or even public participation. We'd also like to incorporate innovations from the revised rules of the two houses. The NA did its review, I think, 2016, and the NCOP, following that, did its own review of the rules. And the intention is to incorporate some of the innovations carried in those rules. Slide number 3. There are joint rules, new joint rules that were developed in the 5th Parliament, for instance, the establishment of the Committee on the Financial Management of Parliament, functions of the Joint Standing Committee on Defence, disruptions in joint sittings, and standard operating procedures that go with those rules. Those were developed in the 5th Parliament. The code was reviewed in 2014, Code of Ethics, slide number 4. And there were also submissions that were received from that had to do with the Constitutional Review Committee and the Joint Standing Committee on Defence. And there was also a submission from the Office of the Leader of Government Business on rules relating to the LOGB. And there were submissions that were made to the Joint Rules Committee at the time in respect of chapters 1 to 2A. And that was in the 5th Parliament, slide number 5. And there are new rules that were done in this Parliament, those that apply to virtual and hybrid sittings of both the houses and joint committees, and also the issue of alternative venue after the NA chamber was destroyed by the fire. Slide number 6. There are also innovations that we can draw from the NA rules. The inclusion of sources of authority in the rules, adherence to rules, directives, guidelines, general authority of the Speaker, codification and addition of responsibilities for LOGB, revisions of rules of debate, communications of private interest, which was not there before, arrangement of business on the order paper, questions of privilege, functions of whips, and conduct of visitors. There are also innovations that are carried in the NCOP rules that had to do with inclusion, expansion of the role of presiding officers, consultation processes, delegation of functions, appointment of acting chief whip, calling of delegates, points of order, voting by provinces, motions, ministerial briefings, virtual and hybrid sittings. Slide number 8. So today, what will be presented are proposals in respect of Joint Rule 1 to 2. 5th Parliament, and made a few additions. And these chapters deal with application of the rules and joint sittings of the houses, including rules on order, in joint sittings and removal of members, incorporation of the rule of the joint rules enacted in terms of rule on unforeseen eventualities, and insertion into the joint rules of innovations from the two houses. Slide number 9. We are still to present proposals in respect of chapters 3 to 5. and the schedule on the Joint Standing Committee on Intelligence. Those are being cleaned up, and that process has been completed. And Chapter 3 and 2.5 deal with joint committee system, joint legislative process, and stopping of funds to provinces. One of the interesting things that we are exploring on the joint legislative process is the possibility of joint committees to process legislation, but that will come true when we present those inputs. Inputs are being awaited from the Registrar of Members' Interests on possible rule changes related to Ethics Committee and Code of Conduct. And these inputs should be received by the 24th of November or soon thereafter. Therefore, Honorable Chairperson, further meetings of the Joint Subcommittee would request that they be arranged thereafter to receive these presentations. As I indicated, we are hard at work when it comes to chapters 3 to 5, including the issue of ethics. And in the coming week, we'll be ready with submissions to this committee. The next slide. Yes, that's the end. At this point, Honorable Chairperson, if you allow me, we may then Advocate Nonyane, who is Undersecretary in the NCOP, to take the committee through our presentation. Thank you.
Thank you, Mr. Kaso. I think we should allow you to continue with the presentation, then we'll take discussions. Thank you. Advocate Noyane may proceed.
Afternoon, Chairperson and Co-Chairperson, Honorable Nyambi, and Honorable members and colleagues. Chair, just as a way of our approach to the presentation, as the Secretary to the National Assembly has indicated, the insertion into Chapter 1 and 2 will be highlighted by underlining, and the deletion will be highlighted by bold in brackets. And the other point that I wanted also to emphasize is that we intend to not spend time on those rules that already were incorporated from both houses, because we understand that members are already familiar with those rules, but rather to put more emphasis on what has been referred to as innovation. And we thought that we will rather afford members more time for questions instead of us as technocrats talking to these rules, as some of the rules really members are familiar with, but they might want to engage us in terms of their operation when it comes to the joint sittings. The Chapter 1 in particular, ma'am, is focused mainly on definitions, whereas Chapter 2 is the one then that deals with the joint sittings. On Chapter 1, on the definitions, some of these definitions have been there. It's just that on the joint rules, they needed to be cleaned up, or some of them they were not there, but they are not new at all. As members can see, the definition of a chairperson, in this instance, it will be reference to the chairperson of the council, and the definition to the word chamber in the rule book. Can you go a little bit up? I'm not really going to definition of a constitution as being inserted as well, definition of a gazette, and the definition of a grave disorder and grossly disorderly conduct. And maybe on the 2, it was felt that we needed to put the definition of the 2, because of sometimes when you go to the text of the rule, you'll realize that also even when it comes to certain sanctions, there might be different based on whether the conduct was just a grave disorder or a grossly disorderly conduct. So that's why then it was felt that it's important as well to define the two. The definition of houses as well is given, and also definition of hybrid, take into account that with the advent of a COVID as well, it has brought in a new way of how Parliament conduct itself, including hybrid and virtual sitting. We also anticipated that, taking into account that the rules really are a long-term document that will be used even before or after the election, there is already a process of allowing members to stand as independent, and that as well might need to be defined so that at least where instances of those nature do arise in the rule book, there is a definition as to how then do we deal with those instances. You can go the next page. Yeah. There's also a definition of misconduct that was also included in the rule book, including, of course, organized local government. As we all know that when it comes to the joint sitting, part of the NCOP's component to the joint sitting is the delegation of SALGA. Also, there was a more expansion, even though it was about expansion of the definition of parliamentary protection services. And this, of course, is informed by court cases that Parliament had to go through, and what those courts, in respect of the roles of your normal protection service, SAPS, and parliamentary protection services. So at least there is that distinction as well. Then there's also a definition of a party included in the rule book, including, of course, a definition of physical joint sitting, and a definition of what a point of order is, as we know that sometimes there tend to be some challenges around what is a point of order and what is it that is not a point of order. But also to assist members, for example, to have a better sense as to what actually is it that is a point of order. Definition of precincts of Parliament, and a definition of a question of privilege is also being inserted. Can go to, I think, page, there you are, just there, yeah. There was also inclusion of a definition of security services. As I indicated earlier on, we needed to distinguish the security services and the protection services, and therefore the definition was the best place really to make it clear of the distinction between the two. There's also a definition of normal, I think, usher of the black rod, and parliamentary conduct, and of course the virtual sitting vis-a-vis hybrid and physical sitting as well. And there was also a feeling, just a little bit up, on the inclusion of what actually are sources of parliamentary procedure, because of members will recall that in most instances, either when rulings are made, members will then want to see what actually informed that ruling, and in most instances, they will then rise and point to a rule book that, but whatever the presiding officer might have ruled on is not contained in the rule. This is just to assist, to say that in assisting presiding officers to conduct the business of the House, and also what informed them when they make rulings is not only the rules, but also they take into account the Constitution, relevant legislation, in this instance will be your powers and privileges, conventions, certain practices that has been there with us at Parliament for some time. And those are some of the things that also inform rulings of presiding officers. And therefore we felt that by having this in the rule book, that will also assist in clarifying those issues that most of the time kept up in raised, to say where is this or what informs this particular ruling, because of members that can't find it in the rule book. The next point, I think 1B, is basically, I think, explaining joint rules of Parliament. And 2, briefly, it just, that rule tries just to clarify what are unforeseen in state of matters eventualities, because of it does happen that the rules does empower presiding officers on those matters that are not foreseen, that they can on the spot make certain ruling in respect of those issues. 2.A, directives and guidelines of joint rules. That also is an insertion. And 2B, this is just rulings of presiding officers, and also to emphasize, which has been there in rules of both houses, the fact that when such rulings are made, that then brings the matter to finality, and also to outline processes for members who may not be satisfied with the rulings of presiding officers. 2.C, that also just to explain, for example, conventions and practices, what are those? 2D, what content is all about, and can go to chapter 2. On chapter 2, in particular, I think 7A. Chapter 2, 7A and 7B deals with, 7A deals with the opening of Parliament, and 7B deals with the present state of the nation's address. Because of, we have noted that, I mean, while the opening of Parliament, I mean, may seem obvious, but sometimes the distinction with the opening of Parliament and the SONA, what we normally refer to as SONA, and the processes that follows under each, can be confused, and therefore we felt that it is proper that at least the two are outlined in the rules, and also what it may require in both the two. And whilst there is also some similarities in respect of, for example, the calling of the joint SONA, and after the opening of Parliament, and also the calling of SONA in that regard. On Rule 8A, alternative venue, as members are fully aware that with the unfortunate situation that happened with the building of the National Assembly, which used to host the joint sitting, the rules needed as well to be alive to that effect, and made provision for alternative joint sitting in that regard. Rule 9, I want to emphasize, has to do with the calling of a joint sitting, and also the date and time in respect of that was just a cleaning of that rule as well. And it, in fact, just emphasize what is currently happening in terms of publishing some of this information on the ATC. Rule 11A, general authority and responsibility of presiding officers during joint sittings. That rule just unpack what are the powers of the presiding officer. And Rule 13, 2 in particular, just outline for the start of a proceeding of a joint sitting, presiding officers must afford members an opportunity for silent prayer or meditation, which are things that are already happening, just to bring them into the rule book, as some of them have been convention all along. Rule 14, and this rule specifically has to do with access to the joint sitting, and the circumstances under which access might be restricted or limited in respect of those that are attending the joint sitting. I intend not to go into detail because of some of them, as I said earlier on, are matters that are already in the rules of both houses, just that they were brought into the joint rules so that at least there's clarity on some of these issues. The innovation, as indicated, even though they are to a larger extent still part of the rules of the two houses, has to do with virtual sitting or hybrid sitting specifically. And as members can see in respect of rule chapter 2A that talks of virtual and hybrid sitting, we start with 14A that talks with the application of the rules when it comes to hybrid and virtual, and also the question of a venue when it comes to hybrid and virtual, in the event that the joint sitting is held virtually, as to what then will be said to be the venue for that joint sitting. And 14C has to do with the papers for the virtual sitting, and 14D is about privileges and application of the joint rules in hybrid or virtual sittings. 14E is also about presiding officers on virtual or hybrid sittings and the powers that they have in that regard. And 14F is about attendance of hybrid and virtual sittings. It's mainly about logging in and all those stuff, which I think in the NCOP, what normally happens is that presiding officers normally will take members through that step. I'm made to understand that in the NA as well, that normally happens, so that at least as members log in or when the proceedings start, no member will have been left out purely because of they didn't understand the processes moving forward. And 14G is on control of microphones, take into account that on virtual sittings, microphones become really the only tool that presiding officers have in terms of engagement with the members. And 14H is about the public access to a hybrid sitting or a virtual sitting. And 14I is one of those innovations that the secretary made mention of, and I is in particular on members ordered to leave the virtual platform. And if Chair, you were to allow me just to go through that rule, if the presiding officer is of the opinion that the member is deliberately contravening a provision of these joint rules, or that the member is disregarding the authority of the chair, or that the member's conduct is grossly disorderly, he or she may order a member to leave the virtual platform immediately for the remainder of the day. And as I indicated earlier on, ma'am, when we were defining disorderly and grossly disorderly conduct, that's where now the issue of grossly disorderly and how then the sanction relating to that then will come into effect. 14J, the removal of members from a virtual platform. This is in the event that 14I has been implemented and the member still doesn't comply with the presiding officer's ruling in that regard, then 14J then kicks in which will then empower the presiding officers then to take measures that will ensure that indeed the ruling of the presiding officer in 14I is implemented. And the rule basically, I think it is just outlined, for example, the presiding officer also then calling upon, for example, the staff that control the virtual platform to then restrict members, the member to that virtual platform. But for in particular, because of what we need to note is that failure to comply with a ruling of a presiding officer, that on its own has certain consequences for those members who may fail to comply. And therefore, for in particular, refer those conduct to a committee, which committee will then deal with it when we deal with all the committees that are being proposed as a way of ensuring that the rules are complied with. Can we then move to Chapter 2B, in particular Rule 15A on freedom of speech in joint sitting? That also, I think, it's a rule that has been there in the rules of both houses, just being incorporated in the joint rules. And 15B is about conduct of members, and that rule spells out basically what I'll refer to, what is expected of members in the joint sitting, and it then outlines all those instances, for an example, members to be seated when the bells have stopped ringing, and what is allowed in the house, or what members can bring in or may not bring in the house. And also the question of dress code in respect of members, the issue around taking of photographs or video footage in the house, and including J, which deals with the adjournment of a joint sitting. Rule 15D, members not to be interrupted. This also I should emphasize as a rule that has been there, it has just been brought into the joint rules and in fact expanded in the joint rules as well. 15F as well, irrelevance or repetition. This is a rule that has been there. It was just cleaned up in order really to read more better. And Rule 15FA, grossly disorderly conduct. This rule spells out that is considered to be grossly disorderly conduct for purpose of ensuring that at least members can distinguish between just a misconduct and a grossly disorderly misconduct, so that at least there is a clear distinction as to what is it then that will fall under this category of offenses. Rule 15GA, that is the removal of members from the chamber. And this has been there as well. I'm not going to spend time on that, just to highlight that we thought we need then to incorporate that part as well in the joint rules, as it has been in both rules of the two houses, but it needed as well to be clearly spelled out so that at least all members know also in the joint rules what is expected. Rule 15H, or might be, let's say, Rule 15I, expression of regret. That rule also has been there. It's just an addition of sub-rule 2. And Rule 15MA, if you can go there, that is control of microphones in the chamber. That is one of the rules that has also been included in the rule book just for purpose of ensuring that there is clear rule in that regard, because of members know that sometimes even after presiding officers have ordered that microphones should be switched off, members will have difficulty really to comprehend as to why then staff have switched off their microphones. So this rule then is complementing that powers that presiding officers have in ensuring that the proceedings of the House run smoothly. Rule 15PA, reflection upon members. I think this rule also has been there. In fact, this is a rule that was previously amended, but it was just contained in the ATC. Is one of those rules that have since been imported into the rule book, including Rule 15PAA, that is reflection upon the Houses of Parliament, its proceedings and decisions as well. Rule 15S on points of order, starting with those that are highlighted or bolded are deletions, and insertion are underlined. They start at number 1. That is a very clearly spelled out processes around points of order. As we know that most of the challenges in the House revolve around points of order. What's a point of order? At what stage a point of order may not be raised, either because of a presiding officer has made a ruling already on that issue, and therefore it should be bringing the matter to a close. So that whole rule deals with those in order really to guide members as well around issues of points of order. 15SA, raising a question of privilege. Also that rules try to draw that distinction between sometimes points of order and points of privilege can be a very confusing issue. So that the two, in fact, this rule specifically try then to distinguish what points of privilege are, and so that at least to guide members when it comes to points of privilege. That Honorable Chairperson should bring me to the end of the presentation. And I should say that we thought a lot of the discussion will arise when members raise issues with this proposal, so that at least we can go into details in terms of explaining some of these rules. Thanks, Chairperson.
Thank you very much, Mr. Nonyana and Mr. Hasso, for both presentations. Honorable members, we have the two presentations that were presented to us. The first one is the framework to the review of the joint rules, which was also presented in the joint rules. Then the second one is the proposed amendments to these rules. So here are the presentations. I want to hear what's your view on these two presentations, honorable members.
Comrade Chair, I want to raise my hand, but just before that, can I ask for your assistance that Mr. Nonyana goes back and take us through point by point in the section with the points of orders and privileges. These are the key important matters. He rushed through that. He stays on that, goes through that effectively, so that I don't repeat. I would want to raise my contribution thereafter.
Okay. All right. Thanks, Honorable Janji. Honorable Korenov, Mr. Nonyane, you'll do likewise when we come to that. Honorable Korenov.
Thank you for the very comprehensive two presentations, both on the framework for the review of the joint rules and the proposed amendments to Chapter 1 and 2A of the joint rules. This is a very important part, because we are now talking about the Joint Rules of Parliament, the 6th edition, that was last amended in June 2011. That's 12 years ago. So I, subject to Mr. Jantjies' proposal, which I would support, I think it's important that we just go line by line on those two. But I've gone through the rules, and I think this is a combination of a number of discussions we had in the subcommittee as well as in the joint rules about the amendment of a review of the joint rules. And I really want to welcome this presentation because it incorporates all of our discussions that we had over many, many months. And we can go in detail again. I support that, but I really want to thank the drafters for this. Going forward, you ask a question about a workshop and public submissions. I want to suggest that we seriously consider if there is agreement about the framework for the review of the joint rules, as well as the proposed amendments to Chapter 1 and to 2A, that we seriously consider to adopt these proposals in this joint subcommittee. And I believe we will go back to the Joint Rules Committee for a recommendation, and that we consider to have a workshop, first of all, to adopt it before the end of the 6th Parliament and not let it stand over for the 7th Parliament. That's number one. And if there is a need, then we adopted in the 6th Parliament that we have a workshop for members of the 6th Parliament on these revised rules. Then I think we should seriously consider that. I'm not sure whether there's any room or make it any sense for it to have public submissions on these amended rules, joint rules that we've been discussed in many meetings over many, many months during the 6th Parliament, even maybe in the 5th Parliament. So I want to make a proposal that we seriously consider to adopt it before the end of the 6th Parliament, so that we have incorporate and consolidate the joint rules and align it with the joint rules, as Mr. Kasu said. And when the 7th Parliament kicks off, then the joint rules are in place. I'm very happy about the removal part that we'll look in more detail into it, especially that there must be consequences. We discussed it previously. You can't have a removal either from the platform or physically, and members stay on the precinct and there's no consequences. So the proposal on the subcommittee and the time frame within 24 hours, that's brilliant. This is what we've discussed. So this is my small contribution. Thank you.
Honorable Korenov is no longer on the platform. Then you will come back. Can I take Honorable Jantjie?
No, Chair, I was hoping that I will come in after Mr. Nonyana would have. I don't want to come back again. Otherwise, I can come in, but I thought I needed that.
Okay. Okay, let me take Honorable Nyambi, Co-Chair.
Thank you, Co-Chair. I was under the impression that because they were sent to us in time, but partly I was fairly covered by Honorable Korenov. Let me join and commend the team for the job well done. So I will agree with you, Chair, that it won't do us any harm to allow Honorable Jantjie to come in now, so that we can engage out of what it's on the amendments. But let's flight the part that is interested in, so that he can be able to go point by point, and then we'll take it from there instead of the other way around. But otherwise, Honorable Korenov has covered much ground, and I agree entirely with him in terms of the process. Thanks, Co-Chair.
Thank you very much, Honorable Nyambi. Honorable Papo.
We have to go to some of 2024.
We can't hear.
Honorable Papo. I think your network is bad. If you can find a better space. Honorable Papo, can you hear me? Honorable Papo? I think he's got some network challenges where he is.
Okay, can you hear me now?
Yes, we can hear you now. You may proceed. Honorable Papo, you are muted.
Okay, can you hear me now?
Yes, we can hear you now.
No, I was using my headphones. I don't know. There's something wrong with my headphones. Each time I'm using my headphone, I have a problem.
Okay.
I was saying we should not go to SONA of 2024 without the amended joint rules. Otherwise, we're going to have another chaos there. And because these loopholes which are there usually happen when we have joint sittings. So my appeal is that we should push that we should have the SONA of 2024 with the adopted rules, and then they can be consolidated and whatever in the 7th Parliament. That's the only input I wanted to add to what Dr. Korenov said. The current status quo cannot continue to exist in 2024 SONA. Thanks.
Thank you very much, Honorable Papo. Let's go back to Honorable Janche. Honorable Mr. Nonyana.
Thank you,
On the
Chair.
issue of the points of orders, yes. You may come in, Honorable Janche.
Thank you, Chair. I think I'll finish with these issues of point of orders, but maybe before that, just some general points and context to make, and then try and deal with the specific ones. But also to add my voice in thanking the team from both houses for the work done. I also want to start with the point of the process, Comrade Chair. You might assist me, and Honorable Nyambi might as well do the same. It would be good for us to know what is the actual date the NA is rising and the NCOP, so that we are able to work backwards in line with the issue raised by Honorable Papo that says anything after December, we must leave Parliament. The joint houses having adopted these rules, so that the next point of a joint sitting, which is going to be SONA, is not affected by the kind of things that we want to address. And so if we then say on this date in December, this is when the NA rises, it means that we must then attend to, especially there's a date of the 24th raised by Mr. Tasso of the Ethics Committee, that it might bring something. It might be important that we take all of those things into account before the final Joint Rules Committee meet and have them kind of attended to. We might also have to, as part of that process, factor in the two houses separately resolving individually around these issues. And I say this so that you leave no particular gap for any challenge of whatever manner. Because what is being tabled and what we're discussing might be far-reaching and might be very stringent, importantly so that other people might not like it and might want to choose a court route. And if we're not precise in the way we do things, we might open that up. So that last date and working backwards has got to take all of those things into account, Chair. My second general comment is that these joint rules were last done in 2011. Since 1999, you have had 5 amendments, and the last edition is that one of 2011. And quite clearly, before 2011, the gap between amending ranged from 1 to 5 years, and 5 years being 2003 and 2008. And it's now 12 years when you don't have a consolidated rule, except that as the presentation was being made, where was shown where other separate amendments were made. And I raise this because that time gap clearly represents some form of inaction. It doesn't represent that everything was smooth running, because most problems came out of the joint sittings. And therefore, it's quite odd that we're not able to do what we're doing now for such a long period. That then says what we're doing is very important and adds to Honorable Hope's point about us working with speed around these issues. If I were to go to just chapter 1, there's an issue that I think I want to start there. On page 3, paragraph 2, it's called unforeseen matters of the joint rules, unforeseen matters. And I go there because I regard this point as very important. It says the Speaker and the Chairperson of the Council, acting jointly, may give a ruling or make a rule in respect of any matter for which the joint rules do not provide. And so the first question that will come is that up to this point, as we do this, we've had this existing, and yet I can't remember it being applied, it being utilized. And the point one is making is that sometimes there's no point in making rules when you are not able to action and enforce that. It's a very important point that should always be taken into account. And I raise it also to take it further to the point of powers of presiding officers. This section should be, it is currently even in the proposed powers of presiding officer is not added. I would like that point to be added because you are not going to be prescriptive of everything, of every rule. But this one is so broad and flexible that it gives the power of discretion to both the chairperson of the council and the speaker. Let alone that I don't remember that being utilized and being effected. And I would want to still bring it back under that section that deals with the powers of presiding officer so that it's there in terms of chapter 1 as proposed now. That's my first specific point, Chair, that I wanted to raise. And then the second point, just as a minor point, perhaps to raise, there's an issue about the microphones, where they must be switched off or disabled. The only challenge with that is that is made, it's phrased in that manner because you think that you are still in the chamber that has not bent, or you are in the NCOP where a member has a microphone in front of him that is gets switched off. It doesn't take into account the last 2 years and the next 2 years that is coming. where you have got mobile microphones. So it's going to have to be a matter of it being disabled, switched off, and I may add, taken away from the member. Because if you don't have those kind of things, when you act in that regard, you could easily be challenged. So I want to and then if you can go to the sources of authority. I think it's 1AB that I'm interested in, the sources of authority for the orders, the application of the rules that we're making. It's a very important point. Again, you might not be able to be very exhaustive in that regard, but there's an area I want clarity on, or perhaps add something. Yes, the 80 sources of authority and application, those that are listed. I was particularly interested in point B so that I can get guidance and clarity here. It says the Act and any other applicable legislation. I would have wanted to add the Act and any other applicable legislation and rules, because the next other points might not, you do need to, unless I've missed it, it's catered for in there, and perhaps I would have just missed it. That's the point. The other point I wanted to attend to. Just the other point on innovations, I didn't get it, Mr. Kaso. I share with all the other innovations and enhancement. I didn't get it in the NA, the innovation on or enhancement on the written questions. In the list that you have provided there, I kind of missed that. Because that's a new kind of arrangement that we did and kind of worked on. And then, Chair, let me go to both Section 57 and 59 of the Constitution. 57, which is applicable to the NA, and I'm sure there's a way it applies to the NCOP. Section 57 deals with the internal arrangements, proceedings, and procedures of the National Assembly. The fact that that house has got constitutionally powers that it can do, and point B of that is instructive in saying that the NA makes rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. I'm raising this so that I don't think that, because these are rules for internal arrangement, as opposed to dealing with legislation and other issues that have got a direct impact and kind of public attachment to it. I would not suggest that because we're doing internal arrangements and our sessions, including this meeting of this subcommittee, the joint rules committee, and the different houses and the joint houses themselves are open to the public in terms of Section 59, in terms of the access and so on. So we do things transparently. I would be very cagey. I would be very reluctant that we open this, because it means every other thing that we do, even if you are meant as a section of the rules, this will you need to go to the public. I don't think that they have the weight for that process compared to the other processes that have a particular impact, because this is more about how we do things as a representative of the people. So I want to discourage so that there should not be any further time for us to go to the public as if we are calling for kind of public hearings. They're already involved in some of these processes. Then the last point, Chair, which that's the point I wanted Mr. Nonyana to assist, the point of orders. Because I think we can amend everything else, enhance everything else. what has to a certain amount brought Parliament into disrepute is what happens on the floor in the glare of the public when you have the president about to take a podium or speaking, and our application of the rules or some existence of them have been very lenient in my view, and so what you would have shared, I would have read, for example, the Eastern Cape section of those rules, which I firmly support. That, and this is where we need to be very clear as to what is it that we're saying on the issues of the point of order at a point when the president is taking the podium, is speaking. I support, and I would want to bring that in, the Eastern Cape practice, that such don't get to be allowed to happen. Otherwise, would have just been doing cosmetic changes. That's how firmly that one would want to support that, so that you bring decorum into that session, you bring stability, and so that the society gets the message uninterrupted without creating incidentals as part of that process. Sorry for being long, Chair, but I just wanted to raise those issues. Thank you.
Thank you, Honorable Janji. I think you have assisted a lot because you have raised some of the issues which some of us were maybe ignorant of. So we really appreciate that. Honorable Kwahube, you are here, Honorable Chief Whip of the DA. Can you please take a bite? Honorable Kwahube? Oh,
She's
all
not
right.
sure. She's not sure.
Any other member?
We'll speak on her behalf.
Any other member want to take a bite before I go back to Mr. Carson, Mr. Noyan?
This is Honorable.
Hello, Honorable.
Hello, can you hear me?
Yes, yes, I can.
Just something in general that I would like to propose. I know that we haven't looked at that section of the joint rules, but in the fifth parliament, we experienced some sort of what will I say, lacunas in the rules when it comes to a bill that's been referred back to Parliament by the President. And I can't recall exactly the issues, but it caused a little bit of procedural problems with a specific bill due to that the rules were not clear on that. I know that we are now to get this rule adopted before SONA. So my proposal would be that we can go on, but please, if we can maybe take some time and in the 7th Parliament look at that section of the joint rules, because a bill that's been referred back by President can only be dealt with in the NCOP under the joint rules. Thank you.
Thank you, Honorable Lapuskakni, for bringing that point up. Honorable members, I want to propose that as much as we have received these presentations were sent to us, and also we are presented with those today. And I want also to agree with the proposal made by some of the honorable members who spoke before me to say that there's a need for us to adopt these rules before the 7th Parliament or before the next SONA, of which I fully agree, because we don't want to have the distractions that we always have during SONA. So we want everyone to listen to what the president has to say. We still have time, honorable members. Honorable Janji raised the question of when are we rising? We are rising on the first week of December, of which I believe, you'll correct me, Honorable Co-Chair Nyambi, the NCOP will rise the following week of December, immediately after the NA. So my take would be, honorable members, that let's give Mr. Klaso and Mr. Nonyane to respond to some of the questions that were raised here. Then I'll make my proposal after that. Mr. Klaso, Mr.
Thank you.
Nonyane?
Thank you, ma'am. Just in terms of the date for adjournment, at this point, the NA is meant to adjourn on the 6th, and the NCOP's last sitting is the 8th. That's the same week. So that is what is reflected on the program at the moment, the 6th and 8th of December. Chair, we have noted the points. Honorable Nonyane will come to the specifics. Unforeseen, yes, we've noted the point raised by Honorable Janji. It was used 2021 on the issue of the venue when 2021 or 2022 that was used, and the Act is referring to the Powers and Privileges Act, and I've noted the issue about written questions, and I also noted the valid point made by Honorable Janji about the issue of public participation. We thought that we should place it before the committee, so that it's the committee that takes that decision, and that we don't take it from a technical point of view as technocrats. Bill referred back by President. We will take care of that, Honorable Abaskakni, when we present the chapter on the legislative program. Certainly, we will take care of that. We will identify the specific bill that the Honorable Member was referring to, and but that will be taken care of. Advocate Nyane, and of course, Advocate Pindela is also here, so he may also come in with the point that he wishes to. For your Chair.
Advocate Nonyane?
Thanks, ma'am. In fact, just briefly, as the Secretary to the NA has covered quite a number of issues that were raised by Honorable Janji. In respect, I think, of Rule 14G, we note your additional proposal, Honorable Janji, that we may as well have to look into that rule in order to ensure that it also takes into account instances where members might be having a roving mic because of you propose, for example, issues of disabled, switch off, or even go as far as taken away. So we'll definitely look into that. And the other issue, I'm not sure whether the Secretary mentioned, but the point that you raised also, or the proposal that you said we need also to look into that Eastern Cape practice. We definitely will then have to look into that as well in order to ensure that we align or we consolidate the rules so that at least proceedings of the House can run smoothly. I think the other point was, or the Secretary has responded in respect of the issue of public participation and the rule that your proposal that may not necessarily the case. Indeed, I may as well confirm what you said, that the NCOP as well has the same rule, that is Rule 70, that deals with internal arrangements, proceedings, and procedure, which is worded exactly the same as Rule 57 of the NCOP. Ma'am, I think on that note, I'll pause here because of the Secretary has also responded to Honorable Labskakne that part will definitely be presented probably in the coming sessions as well. Thanks, ma'am.
Thank you, Advocate Nonyane. Advocate Pindela?
Thank you very
Advocate?
much. Thank you very much, Chairperson. I have nothing to add at this point.
Thank you very much. Mr. Paso and Advocate Nonyana and Pindela. Honorable members, as we have received these presentations of the proposed amendments, I think let's allow for that process of us further consulting with our political parties on these proposals. And also, while doing so, we allow for the parliamentary Abo Mr. Paso to clean up those other chapters that are supposed to come before us. I don't think this consultation will take us for the whole week. We can consult our political parties. Then again next week, Friday, if they are ready with the other chapters, then we come back as a subcommittee to deal with these other issues. Thereafter, we will have to go to the joint rules committee where the rules will then the proposals will have to be adopted. I don't know if we are in agreement, honorable members, that we allow for us to further consult with our political parties on these rules, then we come back, have the same session, then we move on to the next level before Parliament rise. Honorable Janji?
I'm in agreement, Chair, perhaps to just enhance that and add and say it will be very helpful so that as we go to political parties, we don't go with an open-ended process. An open-ended process is not going to help us. We now know the NCOP rises on the 8th of December and the NA on the 6th. Under your leadership and your co-chair, it might be important, perhaps not for discussion here, that together with the officials, NA table and NCOP, you're able to work out properly specific kind of timelines. There might be a need, even before we go to the joint rules, that as this subcommittee we polish certain things based on the contributions we have made here today. So if that can be kind of worked out so that when we consult, they know that there's a time pressure. By this time, because otherwise we're going to be forced to do consultation until the 6th of December. And so if we can work that process out, and I would want to leave that to yourselves, and I still maintain that the two teams of their houses will have to take care of each of their houses, closing any gaps that might be identified where an NA member says, we as an NA, we're hearing this for the first time in the joint rules. We've never had this. We just need to attend to all of those. Otherwise, I'm happy with the noting from both Mr. Klaas and Mr. Nonyana, except to say to Mr. Klaas, the point I was making there in terms of that unforeseen matters, it is a live matter. It's a matter that you deal with it in a joint sitting. And I'm saying we've not been able to attend to that. It's something else when you deal with that outside of that heat and the pressure, because it's an important asset for the presiding officers to have to enhance their leadership. Thank you, Chair.
Thank you very much, Honorable Janji. I think there's no one who's against the proposal that we are making. I can assure you sitting here, and I'm sure that the co-chair also agrees with me, that this is a very important task that we are embarking upon as the two houses of parliament. We really need to finish this work as soon as possible. We received these proposals some few weeks ago, so we already know, and including the discussions of today, Hence, I'm saying, honorable members, let's adjourn the meeting today, allow for those consultations to take place, of which I believe after today's meeting, it's not gonna take long. We will indeed work with the parliamentary officials to check how far are they with the other chapters. Then as soon as we can, a meeting will be called of this nature so that we can finalize and polish everything before the end of November. That is a promise, honorable members. Let me take this opportunity to thank all of you for your participation, your support. Always is really appreciated. So that's where we end our meeting. We will be in touch with the parliamentary officials. Then from there, we will be in communication with your good selves, honorable members. Thank you very much. The meeting stands adjourned.
Thank you, Chairperson.
Thank you.
Namandla, Chair.
Siyabonga.